are we being asked to inquire into a political decision, or are we being asked to determine whether it collides with a precious legal principle?
My Lord, no one, I think in answer to that, no one on our side would dispute the precious nature of the impropriety of purpose principle. It's a well-established principle. It's from Padfield onwards, you have it enshrined in public law. So no one is querying that. The question is how and whether it can operate in the context of this particular decision-making, this type of decision-making. And you've seen from the case law that some otherwise precious principles of public law have to give way. You've also seen from the case law that non-justiciability operates just as much in public law as it does in other spheres of law. So I think my answer to my Lord's question would be to accept the precious nature of that principle, but nevertheless to say the question remains. Can it operate? Can the other principles, which are equally precious, rationality, relevant
Actually, I mean, you've referred to the principle that I was referring to as improper purpose. I was thinking of a bigger one. I mean, if there's anybody who is better placed to defend parliamentary sovereignty, the legal principle of parliamentary sovereignty, it is us here. And it was that principle that I had in mind when I said, does this political decision collide with something which we are duty-bound to uphold?
My Lord, my answer to that is a slightly different one. I'm sorry, I've misunderstood the question. My answer to that is going to be a slightly different one. I've got a section in the submissions specifically about parliamentary sovereignty, but to flag the nature of the answer that I'm going to be giving to my Lord's question when I get there and do it in detail, parliamentary sovereignty, of course, is a precious principle, but it all depends on what it means. What aspect of parliamentary sovereignty, what aspect of parliamentary business are you actually dealing with? It's no good simply turning up and shouting about parliamentary sovereignty, because parliamentary sovereignty means a number of different things. Paradigmatically, parliamentary sovereignty means that Parliament can make and unmake its own laws, and that when it does pass primary legislation, the other pillars of the state, including the courts and the executive, bow to it. So the question
is, it's as limited as that?
I'm going to say that those are the classic features of parliamentary sovereignty, and then I'm going to analyse whether or not it is truly an aspect of parliamentary sovereignty for prorogation to be controlled in this way so as to engage the concerns of the court.